Hi there. I know a lot of you have been following the debate over C-11, which is the Trudeau government's plan to regulate online streaming services, just like this one, YouTube. Well, the bill was controversial because it gives the CRTC authority to regulate user-generated content. So videos like this one, channels like this one, and videos and channels like yours. Well, C-11 is no longer a bill. The law passed on April 27th, the very same night it was given royal assent. So it is now officially the Online Streaming Act. So what now? Well, that's a little bit complicated, but I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, hit like and subscribe below. It really helps my videos out a lot. Also, please remember that nothing in my videos is legal advice. If you have your own legal question or problem, please consult your own lawyer. So as I said, the Online Streaming Act got royal assent on April 27th. The piece of legislation is pretty long, it's 56 pages, and it made changes to an older piece of legislation called the Broadcasting Act, which has not seen any meaningful updates in about 32 years. The government has said that the purpose of the amendments is to update the Broadcasting Act to the digital era, and what it does, according to the government, is put streaming services like YouTube, Crave, Netflix, Spotify, TikTok, Disney Plus, and even Pornhub under the regulatory authority of the CRTC, the Canadian Radio, Television, and Telecommunications Commission. Now, the CRTC has what are called Canadian content requirements for broadcasting. And the streaming platforms I just named are now going to be subject to that Canadian content regime. The government says they are doing this because they want to ensure Canadian content is promoted on digital platforms the way it is on broadcast and radio platforms. Now, there are a few reasons why this claim is perhaps a little disingenuous, but we're going to get into that. First, let's talk about what happens next. Well, the next step is for regulatory work to begin. The government or cabinet has said that they are going to issue a policy direction, but keep in mind any policy direction from cabinet can be amended or repealed at any time. So even if cabinet says that they want to put some special protections in from a policy point of view, well, they can change their mind at any time. The CRTC is also going to start some consultations and create a draft regulatory framework for how they plan to use the new powers that they got from the Online Streaming Act. And those consultations are probably going to include some public consultations. The CRTC has discretion in how to exercise their new powers, so they could decide to exempt some services, some classes within those services. They could say certain user-generated content is exempt from regulatory obligations in the Canadian content regime, but we don't know yet, and no protections are provided in the legislation. It would just be at the discretion of the CRTC. The CRTC is also in the process of reconsidering the definition of Canadian content. I'm going to get into that as well in this video, but it's important to remember whatever the definition they come up with is going to have really big implications for how this authority under the Broadcasting Act is used. So as I said at the beginning, and obviously I think you probably all know, that this bill has been very controversial. There are three main areas of controversy that I am interested in. First, how this law can be used to regulate user-generated content, like this very video that you are watching, but also a video that you might upload. Second, what will be that new definition of Canadian content going forward? The current definition of Canadian content is really narrow, it's really esoteric, it's very confusing, and it's really within the realm of only a few experts who can actually navigate that system. There is a process in place right now to change that definition, but that process is also very confusing and esoteric. But whatever the new definition is, as I said, is going to have really big implications for how the CRTC exercises its powers under the Online Streaming Act. And the third area of controversy that I am interested in, especially as a constitutional lawyer working with a constitutional law charity, is if the CRTC is going to be regulating user-generated content for Canadian content, does that have implications for the right to freedom of expression as guaranteed by the Charter? And is this law going to lead to a kind of censorship? So let's go through these controversies one by one. First, how is this law going to regulate user-generated content? Well, it absolutely is clear that the law gives the authority to CRTC to regulate user-generated content. Any government claims to the contrary, that the law does not give the CRTC that authority, those claims are false. And if you listen to what the government says, they don't actually say the CRTC can't do that. They kind of say, oh, they won't, that's not their intention. They've repeatedly emphasized their intention, but the intention of the government needs to be differentiated from what the law actually could permit. And under the law, the specific section is section 4.2 sub 2. It clearly scopes into CRTC authority the power to regulate user-generated content. It gives the CRTC the power to regulate most audiovisual content at their discretion, and it's based on 3 criteria. First is whether the content generates revenue either directly or indirectly for someone. And it's important to remember that most content on streaming services, even amateur content, is generating video revenue for someone. This video is generating some revenue because ads are run before and after, and I am not a professional YouTuber. The other criteria can be if any part of the content has been broadcast on a more traditional broadcasting platform. And then third, if the content has been assigned a unique identifier under any international standard system. And this unique identifier criteria also applies to most content you see online as well. So the CRTC clearly does have authority to regulate user-generated content now that C-11 has passed. Although, as I said, that regulation will be at their discretion and it will be subject to the policy direction that the Trudeau cabinet provides to the CRTC. Although again, that policy direction can change at any time. Now, the government and the Heritage Minister in particular have really been hammering this drum that it is not their intention to regulate users. The reason they say they need this revenue test and this unique identifier test is for this scenario that they keep using. They say they need these tests that ends up capturing user-generated content, but they need it because if a song appears on both YouTube and Spotify, they should be treated the same way. But this is just like a really misleading scenario for a whole lot of reasons. First, the language of the bill is just really clear that Section 4.2 grants the CRTC the power to establish regulation on programs, including audio and visual programs. So no matter what the government says, user-generated content is scoped in. Second, if their concern was this hypothetical scenario about a song on YouTube and Spotify, the Senate actually, took the government at their word that that was their concern, and they proposed an amendment to change the revenue test and the unique identifier test. The Senate amendment, which was this addition of a proposed section 4.2.2, and it removed the revenue generation test, and it also said that the unique identifier criteria should specifically target sound recordings and removed things like podcasts from the capture of C-11. The Senate really tried to tailor an amendment to address what government said was their concern. So that should be good enough, right? Well, what do you think happened? Well, the Trudeau government rejected the amendment. So if the intention of the government is not to regulate users, which is what they claim, why did they reject the Senate amendments that would have sort of created this exemption and solved the problem the government said they were trying to solve? Is it because they really do want to retain the power to regulate users? I'll leave that question for you to decide. The third thing I want to say about the regulation of user-generated content is that even if the government has stated that regulating user-generated content is not their intention, we have heard from industry lobby groups, from legacy media who support the legislation, and they have said they absolutely want to be given preference by the algorithm. And it's so important to know that the algorithm for streaming platforms is binary. If one thing goes up, something else has to come down. And so if a CBC video is promoted to page 1 on YouTube because the government has put its thumb on the scale, that means another video needs to be moved down. And if you are on page 10 of YouTube, no one is going to find your content. We cannot all be number 1 at the same time. The government has created the power for the CRTC to tip those scales. But the question, as I said, is going to be how the power is going to be used now that the CRTC has it. Maybe the CRTC will choose to create special exemptions to carve out special types of content and exempt them from Canadian content regulations. But that is going to require a level of trust in the CRTC that I don't think it's appropriate to have from a philosophical point of view, but from a practical point of view, based on the history of the decisions and policies by the CRTC, I don't think it's warranted. The CRTC is currently considering the question of whether or not to ban Fox News cable in Canada. So I don't think they are deserving of trust that they will act in a way that is not going to cause harm to digital content creators. If the government intention, as they claim it is not to regulate user-generated content, make that clear in the legislation. Don't give the CRTC the power to regulate it and then trust that they're not going to use that power in an abusive way. The protections need to be in the legislation. So let's consider the second issue now, which is that definition of Canadian content. Since the government says the whole point of this is to lift up Canadian content, tell more Canadian stories, and we all need more exposure to that. Now, the current definition of Canadian content is long, it is complicated, it uses a point system that awards points based on the nationality of people in the production team, based on production. It has production cost requirements, it has salary requirements for Canadian producers relative to foreign producers, and to qualify, the content actually also needs to be within a CRTC defined program category. So this video, under the current definition, which is created by me, a Canadian. I'm even wearing my Toronto Maple Leafs shirt. It is filmed in Canada. It is a video about Canadian law. 90% of my viewers are Canadian. Well, under the current CRTC definition, this video is not Canadian content. And even if it could qualify as Canadian content, to get it qualified, I would need to fill out huge amounts of paperwork for every single video that I upload. Now, I am a lawyer. I am not afraid of paperwork, but even I couldn't do this. I just do not have the time or the resources. So do you think a teenager on TikTok or a gamer about to go live on Twitch is gonna fill out forms of paperwork in order to get certified as CanCon? Of course not. The Canadian content regime is entirely set up to benefit legacy media, many of whom are not even on these streaming platforms. So when the government tells us that the legislation, the Online Streaming Act, is about helping to boost that Canadian content, well, I think it's pretty disingenuous. They're talking about a very specific type of Canadian content. And since, as I said, all these algorithms are binary, boosting legacy media CanCon is always going to be at the expense of downgrading user-generated content, even if that content, like mine, is as Canadian as it gets. Another thing, though, is that even if my content did qualify as Canadian content, and even if the CRTC did decide to put its thumb on the scale to boost up my videos, I don't want that. I don't want to get a bunch of downvotes on my videos because they were promoted to people who don't want to see them. If you come on YouTube because you want to watch some old Friends clips, or if you want to learn about how to improve your skincare routine, both are great types of videos. I watch both. But instead of getting those videos that you want, you get my opinionated videos about constitutional law. That's not going to work out well for me. People are going to downvote my video. They are going to navigate away immediately, and that ends up hurting how my videos perform on YouTube, and the algorithm will itself move me down, which is a good time to remind you to please like my video, leave a comment, and watch to the end, because that's one of the best ways to help me. So the legislation is not even going to help me, and to the extent that a new definition of Canadian content could possibly include me, which I think it almost certainly will not, it still is not going to help me. Now, the government has said that they are in the process of updating that definition, but we don't know very much about that process. That process is very unclear. But aside from that, obviously, the update should have happened before the legislation was passed. It is just not good enough to give these sweeping powers to the CRTC and then tell all of us who use these platforms, oh, we trust that the CRTC is going to do the right thing. I'm not a professional YouTuber, but many people are, and that's their livelihood. This is a real industry, and it's a valuable industry. And in what other context would the government ever create ambiguous legislation that could have harmful effects on a huge industry and say, just trust us, we're going to give these regulators the powers to do all kinds of things that could hurt you, but they're probably going to do a good job, and we'll iron out the details later. We absolutely should have known what this update to the CanCon definition was going to be before C-11 was passed. So the last point of controversy that I want to talk about and that I'm interested in as a lawyer who works for a constitutional law charity is how C-11, or the Online Streaming Act, can impact the right to freedom of expression that is guaranteed by our charter. Now, the law itself doesn't limit the ability to speak, but it could impact the ability to be heard depending on how the CRTC exercises its powers. Now, this question of impacting the right to be heard has important implications for the right to freedom of expression, and it's an important part of the conversation that was not seriously considered during the passing of this legislation. There's an often cited analogy by critics of the bill and now legislation that if the government tried to regulate what books go in the front window of a bookstore and what books need to go in the back, we would all say that this is a freedom of expression problem. But again, we still don't know how the CRTC is going to use these powers. We're going to have to wait and see. So to the extent that any constitutional challenge could happen, the answer to that question is really going to depend on what the CRTC does. So what next? As I said, the legislation is going to head to the next phase, which is that policy direction from Cabinet, the CRTC consultation that is going to maybe clean up some of the uncertainty around how the CRTC plans to use this law for now, followed probably by years and years of hearings at the CRTC and appeals of CRTC decisions. Professor Michael Geist, who is one of Canada's leading scholars on media issues, has said that sometime in the future, and his best guess is 2025 or 2026, he thinks that digital creators are going to have to keep going to Ottawa to appear in front of the CRTC to ask for a more hands-off regulatory approach. And he also thinks that legacy media industry who supported this legislation is probably going to find that the bill is less helpful to them than they had hoped. So again, on issues of constitutional challenge, we can't bring a challenge right now. We really have to wait and see how this process plays out and how the CRTC exercises that authority. Okay, I hope this video was helpful for you and you learned something about the legislation and what it's going to mean for you as a digital content consumer, as well as a digital content creator if you create content online, and almost all of us do to some degree. If you like this video, help out that algorithm, give it a thumbs up, share it, please boost it up ahead of those CBC videos. I really need your help. And also share the video with someone who you think might enjoy it. You can also stay up to date on all of our other cases by signing up for our email freedom updates at theccf.ca/freedom updates and by subscribing to this channel and ringing the notification bell so you never miss one of my updates. I'm really looking forward to giving you more updates as this legislation gets implemented, and I really am hoping that the updates will be good, but I'm not especially optimistic. Okay, that's all for today. Thanks for watching, and let's keep fighting for freedom in Canada.